Good day, ma'am. Today I am reporting the effect of mitigating circumstance. Mitigating circumstance or extenuating circumstance are factors that tend to lessen the severity of crime or its punishment by making the defendant's conduct understandable or less blameworthy. Mitigating circumstance might include a defendant's young age, mental illness or addiction, or minor role in the crime. For example, two people rob a convenience store at gunpoint. One is a 13 years old girl with no criminal record. She's run away and has a serious drug addiction. The other is her 26-year-old boyfriend. He has a long criminal history, including other armed robberies. The robbery was his idea, and he planned the crime and obtained the weapons. Are these two people equally responsible for their criminal conduct? How mitigating circumstances are used. In law, the concept of mitigating circumstance is broad, and the term may mean different things to different judges. Sometimes, it refers only to factors that impact sentencing. Other times, it refers to anything short of a defense that makes the defendant's criminal behavior less blameworthy and results in less serious charge of sentence. Sometimes, a factor that one state considered to be an affirmative defense might be a mitigating circumstance in another. And decision-makers in criminal justice system, such as police officers, prosecutors, judges, are always considering mitigating circumstance, along with all the other facts in deciding how best to handle a case. If a person with a developmental disability steals a soda from a store, a police officer might decide not to make an arrest. A prosecutor might not file criminal charges. The jury might decide not to convict, or a judge might impose lighter sentence. In contrast, aggravating circumstances make a crime more severe or serious. Common aggravating circumstances include the defendant's lengthy prior record, use of a weapon, or targeting of a vulnerable victim. Difference between ordinary and privileged mitigating circumstance. Ordinary mitigating allows the reduction of period of the penalty imposed such as minimum, medium, and maximum period, except when there is a presence of aggravating circumstance or several. For example, the imposable penalty for the felony or homicide supposedly committed by an offender is reclusion temporal, and he was able to prove one ordinary mitigating circumstance. No generic aggravating circumstance have proved in this case. His penalty will reduce to reclusion temporal in its minimum period for every mitigating circumstance present in the criminal act. One period within the penalty imposed will be deducted, therefore, until the applicable period is the minimum. What is privileged mitigating circumstance? Privileged mitigating circumstances are those that mitigate criminal liability of the crime being modified to 1 or 2 degrees lower. This circumstance cannot be offset by aggravating circumstance. The circumstance of incomplete justification or exemption. For example, when majority of the conditions are present, and the circumstance of the minority if the child above 15 years old age acted with discernment, are privileged to mitigating circumstance. Question number 2. Privilege mitigating circumstance from an ordinary mitigating circumstance as, as to reduction of penalty and offsetting against aggravating circumstance. The distinction between ordinary and privilege mitigating circumstance are, under the rules of Application of divisible penalties under Article 64 of the Revised Penal Code of the Philippines. The presence of mitigating circumstance has the effect of applying the divisible penalty in its minimum period. Under the rule on graduation of penalty, Article 68 and 69. The presence of privileged mitigating circumstance has the effect of reducing the penalty 1 or 2 degrees lower. Ordinary mitigating circumstance can be offset by aggravating circumstance. Privileged mitigating circumstance are not subject to offset rule. Article 13 of the Revised Penal Code, Mitigating Circumstances. Number 1. Those mentioned in the preceding chapter when all the requisites necessary to justify the actor exempt from criminal liability in the respective case are not attendant. 2. That the offender is under 18 years old age or over 17 years. In the case of the minor, he shall proceed against in accordance with the provision of Article 80. That the offender had no intention to commit so grave a wrong as that committed. That sufficient provocation or threat on the part of the offended party immediately precede the act. That the act was committed in the immediate vindication of a grave offense, the one committing the felony, or delicto, is his spouse, ascendants, descendants, legitimate, natural, or adopted brother, or sister, or relatives by affinity within the same degrees. In addition, ordinary mitigating is already enumerated in subsections 1 to 10 of Article 13. Privileged mitigating circumstance in the article number 68. Penalty to be imposed upon a person under 18 years old of age. Upon a person is under 15 but over 9, that he acted with discernment, a desertion penalty but always 2 degrees lower. Upon a person over 15, under 18, penalty next lower than the prescribed by law. On the article number 69, penalty to be imposed when the crime is committed is not wholly excusable, penalty lower by 1 or 2 degree. On the article number 64, rules for the application of penalties which contain 3 periods. Privilege mitigating circumstance applicable only to particular crime. Voluntary release of a person illegally detained within 3 days without the offender attaining his purpose, and before the institution of criminal action, penalty is 1 degree lower. On the article number 268, paragraph 3. Abandonment without jurisdiction of the spouse who committed adultery, penalty is 1 degree lower. On the article number 333, paragraph 3. On the distinction on the ordinary mitigating circumstance and the privileged mitigating. On ordinary, offset by any aggravating circumstance, produce only the effect of applying the penalty provided by law of the crime in its minimum period in case of penalty divisible penalty. On privilege mitigating cannot be offset by aggravating circumstance produce the effect of imposing upon the offender the penalty lower by 1 or 2 degrees than that provided by the law of the crime. On mitigating circumstance, those mentioned in preceding chapter when all requisites necessary to justify the act or to exempt from the criminal liability in the respective case are not attendant, is applicable only when unlawful aggression is present, but the other 2 requisites are not present in any of the case referred to in circumstance number 1, 2, 3 of Article number 11 is entitled to privilege mitigating circumstance referred to it on the article number 69. Incomplete self-defense or relatives and defense of strangers. First requisite is the present, but the other two are not. Incomplete justifying circumstance of avoidance of greater evil or injury. The last two requisites are not present. Incompletely justifying circumstance of performance of duty, where only one of the two requisites are present. Number one is that the accused acted in the performance of a duty or in the lawful exercise of right, and that the injury caused or offense committed be necessary consequence of the due performance of such duty or the lawful exercise of such right or office. Incomplete justifying circumstance of obedience to an order when all the requisites necessary to exempt from criminal liability are not attendant. Number one is complete accepting circumstance of minority over 9 and under 15 years old. Mitigating circumstance where only of the two requisites are present, that the offender is over 9 and under 15 years old, or that he does not act with discernment. Incomplete accepting circumstance of accident. These four requisites must be present in order to exempt one from criminal liability. A person is performing a lawful act. Number two, with due care. 3. He caused an injury to another by mere accident, and without fault or intention causing it.